Well, stay with us. We're going to go to Washington and attorney Eric Lisann. First of all, remind us, what is the 14th Amendment of the U.S. Constitution?
Very important, very good question. The 14th Amendment was passed in the wake of the Civil War, which, as everybody more or less knows, was fought between the states in the War of Succession. It's literally called in the French translation of it, because half the country, more or less, the southern states, wanted to secede from the Union because they objected to, notably, the institution of slavery being banned at the federal level. So after that, when the North won and the country was reunified, the South was considered traitorous. They were insurrectionists. I mean, these very people that were now seeking to come back into public office had been literally killing Union soldiers and civilians during the war, and they had been proclaiming that there should no longer be a United States, at least that they wanted to be part of, in the way that was envisioned in the Constitution. So this was a huge issue, and the Congress led the efforts to pass a constitutional amendment, the 14th Amendment, which has several sections. But the one we're talking about here, Section 3, notably says, look, if you have previously been an official in the United States government and sworn an oath to uphold the Constitution and then violated that Constitution, you cannot return to government. So, in other words, Jefferson Davis, for example, who was the president of the Confederacy, had he had it in his mind, of course, at the time that would have been considered crazy, but say he had taken it in his head to become president of the United States and run against Lincoln or Ulysses S. Grant or whoever, he would have been banned by this provision. And in fact, several people running for Congress were banned by it. So
right.
This is what we're talking about. This is the provision of the Constitution that's at issue here.
And what we're seeing, the last time the U.S. Supreme Court delved into an election in such a direct manner was in 2000, when it stopped a recount in Florida, and George W. Bush, by a slender margin, won the presidency over Al Gore. If the case does go to the Supreme Court, it looks like it might. Eric Lisann, will this be, again, this time it won't be about procedure. This time it'll be actually about, as you just described it, an article of the Constitution.
Yes, it will be pure constitutional law directly applied. Does this provision, it's only one sentence basically, in Section 3 of the 14th Amendment, mean what it says by its text?
And we had back in 2000 a partisan vote, 5-4. This time there are 6 justices appointed by Republicans versus 3 appointed by Democrats. Will it be a partisan vote this time? Well,
you have to think that that's going to be a concern, just to be realistic. Now, I would note that Judge Lutig, a former appellate federal judge, was on the airwaves last night in the United States saying he didn't think it would be, and he's been a big leader in sort of the civic awareness contest of promoting the problems that Trump faces because, according to Lutig and many others, Trump is disqualified from office as an insurrectionist. He said he has faith in the Supreme Court to rule strictly upon the law, and the law is clear. And I agree with that part of it, that the textual language is very clear. But to be realistic, especially in light of all of the turbulence and all of the cases, many of which you and I have discussed over the years by these same justices, you have to think that there's no avoiding the partisan nature of this. And that's going to be the big question that's looming over everything.
All right, another test for U.S. democracy coming up. Eric Lisann, many thanks for joining us from Washington. Many thanks as well to Douglas Herbert.